Right. So one of the elements of the doctrine of undisclosed principle is that the agent must act with an actual authority for the principal to be able to intervene on the contract between the third party and the agent. This intervention on behalf of the principal, or of the principal, I should say, is in some cases excluded expressly by the contract, or it could be impliedly excluded by the contract. But more difficult cases are where there is something about the person of the principal or the person of the agent that is important to the third party. So we should focus on the latter first. So what if the third party wants to contract with the person in front of them, and they don't say so expressly in the contract, but it's important that they contract with the person in front of them. And a case that illustrates the issues and the drawing of the line when the principal can intervene or not is quite well, is Siu In Kwan, the advice of Privy Council, and the facts were that there were 2 seamen killed by a typhoon, and their representatives, personal representatives, after their death, claimed against the employer for a payout because they were killed during their employment. The employer was bust at that point, so the question was whether they could sue the insurance company with whom the employer had insurance arranged for a payout of proceeds under the life insurance policy. And the employer did in fact have the insurance in place, and this insurance, the life insurance of their employees, was arranged by a third party, by an agent, shipping agent. And when that agent was arranging some years before that insurance, the terms of the insurance did not specify specifically the employees, but they did mention the Osprey, that the insurance covered the Osprey, which was the ship on which those 2 men worked and were subsequently killed. So the question there was whether the insurance company, as a third party, could be bound by the act which was undertaken by the shipping agents on behalf of the employer. If the employer, as the undisclosed principal, were in a position to sue the insurance company for insurance of those 2 men, then also the personal representatives of those men after their death were able to sue. The insurance, of course, the insurers argued that they were not liable precisely because the contract was such that they were insuring a specific person, and the employees were not mentioned. So there was their argument was not accepted. The advice of the Privy Council was that, on appeal from Hong Kong, by the way, was that the employer was able to sue the insurer, and rather than showing whether the employer was mentioned in the policy or not, the Privy Council said that, well, this is a doctrine of undisclosed principle. Even though the principle was undisclosed, when the agent acted with actual authority, which they were able to sue the insurer. And it was for the insurance company they ought to have had the foresight to exclude expressly in the contract anybody else if they did not want anyone else other than the person in front of them at the time to sue. And the contract of insurance enacted between the insurers and the shipping agent did not exclude a third-party intervention. And secondly, in any case, the person of the insured, did not matter. As Lord Lloyd says, the actual identity of the employer was a matter of indifference to the insurer. It was not material to the risk. And the contract of insurance is about assessment of the risk from the perspective of the insurer. This is really what ought to matter to them. The personality of the person insured, who they were, was not material to assessment of that risk. So, another context which we need to establish is whether a third party could argue that it's the person of the principal that was so repugnant to the third party that they are so important that they did not want to conclude a contract with them. Now, there may be situations, as in the old case of Archer and Stone, where a third party specifically asks the agent, the person contracting with them, are you acting for somebody else? Yes or no? If the agent says, no, I'm not, I'm acting just for myself, then the contract is only between the agent, even though they really try to act for somebody else, and the third party. The principal cannot intervene. But as in another case in Dister, if the principal specifically employs an agent to purchase a piece of land from a seller, and the principal has knowledge that the third party doesn't want to contract with them, but the third party seller, in this case of land, doesn't ask whether the agent is acting for anyone else or not, then the fact that the principal knew that the third party wouldn't contract with them because they didn't like them, as was the case here, that is not a factor that will preclude the principal from intervening on the contract, so long as there was actual authority conferred by the principal on the agent to act on his behalf. A good illustration of this is the Said and Butt case, which was a case of a very vigorous theatre critic who was trying to purchase tickets for this performance premiere. And he was very much unwelcome in the Palace Theatre. You can only imagine why, for his past behaviour. And he was denied sale of the tickets for this particular theatre performance. So he employed an agent to go and buy those tickets for him. When he got the tickets, he went ahead and tried to attend the play, saying that he bought the tickets by employing an agent. He was ejected from the theatre, and when this happened, he claimed damages. Now, the court took pity. He said, McCarty Justice said that Said, as undisclosed principal, could nonetheless not intervene. They took pity on the theatre because there was a striking characteristic present. The person of the critic was so unwelcome. The personal element was so strong that he was not able to ratify the contract for the purchase of the tickets. The justification of this case, the reasoning of the judge is not the most convincing, and you could think of better ways of justifying why purchasing the theatre tickets for a premiere really ought to be about the contract between the person who's buying the tickets and the theatre rather than a third party. So you could, for example, argue that there are only limited number of guests, perhaps special guests because it is a premiere, and you might come up with other arguments. In the case itself, there's some discussion about mistake. So you might have come across this case in your earlier years in contract law if you discussed this case in light of unilateral mistake. But Lord Millett in Shogun Finance makes it quite clear that he doesn't think that this had anything to do with mistake. Rather, it's to do with this striking element being present. Another important aspect of the undisclosed principal doctrine is that the agent must intend to act on behalf of the principal. Now think about it. The agent must intend to act on behalf of the principal. The third party knows that they're only dealing with the person in front of them, so they don't know that there is a principal behind the agent. So it's only the agent that must intend to so act. How do we determine this intention? In National Oil Well, we are told that what we're looking for is the subjective intention of the agent to act on behalf of the principal. Of course, we look at the terms of any document, any contract between the principal and other contracting party. National Oil Well was another insurance case, by the way. But ultimately what we're looking for is for evidence from these documents that will show that the agent subjectively intended to act on behalf of the principal and bind the principal and not themselves to the contract. This subjective approach is difficult because we do not yet have a perfect ability to read another person's mind. Leggett in Magellan's Spirit, in a more recent case, it's only first instance decision, but he makes very clear that this subjective approach is unacceptable. Contract law, entering into contracts, should be based on disclosed intentions, objectively determined intentions, not subjective intentions, what was in a person's mind and trying to prove them. But nonetheless, this recent dictum aside, which is somewhat controversial and obiter, it seems that the majority of scholars, at least, take the view that what we are looking for is a subjective intention on behalf of the agent to act on behalf of the principal. Because what we are looking for is not evidence that there is the existence of the contractual interpretations. So the existence of the contractual obligations and rights does not depend on the agent's intention. It's only whether those obligations or rights are owed to the agent or the principal. Whereas the objective approach is whether there is a contract in the first place. So that's why the dictum by Leggett should be doubted somewhat, because he seems to place too great an emphasis on the importance of the objective approach, not only in relation to the existence of the obligations on the contract, but also to whom they are owed. And that we could use this to perhaps say that this is only obiter. and should not necessarily be followed in the future, but we shall see. It's a controversial area. Now, the last point on the undisclosed undisclosed principle, is the question of the basis for this doctrine. And I wanted to discuss this now rather than earlier, as originally intended, because I wanted to refer to what I just said. The basis, the entire doctrine of undisclosed principle is seen as anomalous by Leggett in Magellan case. He thinks that this doctrine is an anomaly in English law precisely because it's about placing emphasis on undisclosed intentions. The contract is concluded between a third party and a principal whose existence is unknown to the third party. And civil obligations should not be created on undisclosed intentions. He does note, however, Leggett, that the presence of the doctrine is well established in English law, but he does regard it as an anomaly. And he refers to the case of Keeley and Maxted. So this case, Keeley and Maxted, is an important one. It does come up in all sorts of contexts. Strongly encourage you to read that one as well. And Lord Lindley, in that case, tells us that the explanation of the doctrine of an undisclosed principle, that they can sue and be sued on a contract, is that the contract is in truth, although not in form, between the principal, undisclosed, and the third party. However, that truth is only known to the principal, and it's not known to the other contracted party. And he does recognise that this is an anomaly in holding one person bound to another, where the other did not know with whom they contract. However, he does try to justify the existence of the doctrine by saying that they are contracts concluded by agents who are undisclosed are common and useful in business transactions. Great mass of contracts, he says, is concluded in this way. And it's extremely convenient that it should continue to be so, and that the principal should be able to sue and be sued the third party, even though they were undisclosed. A similar explanation based on practicality of this doctrine of undisclosed agency is advanced by Lord Justice Diplock in Freeman and Lockyer, where he stresses that the doctrine simply avoids circuity of action, because if it weren't for this doctrine, all that would happen is that if anything goes wrong with a contract with a third party, the principal would have to sue the agent for not performing what the agent was contracted to perform, for not acting within the scope of actual authority. Then the agent would be at a loss, so they would then have to sue the third party for not performing their side of the bargain. So rather than having all those suits, it's much easier that the principal can directly sue the third party for not performing the contract. And similarly, if we consider the position of the third party wanting to sue the agent, rather than the third party suing the agent and then the agent suing the principal, it's much easier simply to have a principal third party connection. Now, what's important is that in practice, it's all very well to have this justification, the practical justification, that it's useful to have this doctrine. But conceptually, it does sit quite uncomfortably in the law, and particularly with the idea of the undisclosed intentions of the principal to be bound to the contract. So the third party does not know who they contract with. So if this is such a problem, what we could say, and what Lord Justice Diplock says in Taylor, case is that, well, we shouldn't be so worried about the third party, who they want to contract with. Because the third party sometimes contracts with a person in front of them and they really don't care who this is. For example, they've got some goods they want to sell and they don't care whether they sell to A, B or C. So we shouldn't be so hung up on the idea that the principal enters into a contract and they're bound to this other person and they undertake obligations and have rights against someone and they don't know whom. It's just not important because we should not be worried about who the third party wants to contract with. In fact, Diplock says we can assume that the third party is willing to contract with other undisclosed principals. This can be assumed by the agent. This willingness to act can be assumed. But nonetheless, undisclosed principal doctrine, very useful, but it is quite controversial and anomalous because ultimately you are looking at a situation where a third party can intervene on the contract who was not a party, who did not appear to be a party to that contract before. Okay, do you have any questions on the undisclosed principal doctrine? Yes?
Yeah, so how far can one say that so if the agent is contracting with the third party on behalf of the undisclosed principal, and the agent knows that just from observing the third party that the third party would not want to be in an agreement with the principal, then that would vitiate the agreement?
Well, not necessarily. It depends on the terms of the contract between the agent and the third party. So if we think about the case of selling land to someone to whom the seller did not really want to sell, if the agent knows this, that's not relevant to the ability of the principal to intervene on the contract. Principal can still do it. But if the agent's knowledge is so strong, so as to become, so perhaps it's so strong that it becomes evidence of the term of the contract between the agent and the third party, that no other person can intervene, then that would be sufficient to preclude intervention of the principal. On the other hand, you've got also the cases of insurance, such as the Sue kind of case, where sometimes you might say the insurance is for specific people, and if those other people are trying to intervene on that contract and they pose, for example, greater risk, then they would not be able to intervene and sue on that contract.
So it's sort of down to the judge's discretion.
Well, it's a question of judgment, but conceptually it's about where you draw the line. So I think it's useful to look at the principles and the judgment of Lord Lloyd in Sue Kwan, because he does talk about the importance of the personality of the person, of the agent, whether it was so important that they wanted to contract with only the agent, or whether they were entering into a contract, and it really should not matter.
It doesn't matter.
Yeah.
So can we not just put it to one side and see cases like Said and Butt as anomalous and irrelevant? Because it's undermining to certainty of trade for a third party to renege on the agreement just because there happens to be a principle behind the agent who the third party doesn't really like.
Well, I mean, that's the argument in favour of having wide undisclosed principle doctrine, and it does, and it is used very widely. And we could say that Said and Butt is exceptional in that sense. But you will be looking at various circumstances where the person of the other party to the contract is just so important that there is an argument to be made on either side. So I think it's important that there is the possibility of making, of not applying the undisclosed principle doctrine.
So It's just one more thing. So if it's such that the other party, the third party, would never have entered into the agreement had they known the identity or personality of the principal, then that would vitiate the agreement between the agent and the third party.
Well, no, because then it depends on whether that intention was manifested, expressed to the agent or not. So there has to be more than just the third party saying, I would never have done it had I really known the truth.
But if the agent had indication to suggest that?
Well, again, it goes back to how much of a term of a contract this is and how much of a strong indication it is, analogous to Said, for example. Okay. Right. Any other questions from everybody else? No? Okay. Now, the undisclosed principle doctrine does, so again, like apparent authority, it's relevant in problem questions where you have to determine whether, even though the existence of the principle was not known to the third party, whether the principle can intervene. But also, it's a question of how do you balance the interests of the third party and the principle of who can intervene on the contract, who can sue the third party, even though the existence of that party was not clear. So it does raise both practical questions, problem questions, if you like, it's relevant to problem questions, but also relevant to essay type questions. Now, there are some unusual cases in English law, and one of them is Watteau and Fenwick, which cannot be very easily explained by any of the existing accepted principles. So Watteau and Fenwick was a case of a pub where the owner of a pub sold the pub to a third party. The third party buying the hotel, the pub, agreed to keep the owner, the previous owner of the pub, as the manager, and they told him that he could only buy certain things. And the former owner, now the manager, went off and bought some cigars, which was clearly outside authority. And the third party was unaware that the person they sold the cigars to was no longer the owner of the pub, but only the manager. So the manager of the pub acted both as an agent for a principal who was undisclosed, and also outside authority. So the question, can the third party sue the actual owner of the pub, the undisclosed principal, who did not authorize the purchase of cigars? The answer should be no. But the court said that they could succeed in a claim against the current owner of the pub. So this case wreaks havoc with the principles because we need to explain somehow what is so special about this case that enables the third party to sue. And there are multiple explanations. One is that we're looking at an apparent ownership here. We're looking at a specific case of the person appears to be the owner of the pub based on the previous track record. The third party believed they were dealing with the owner, who had all the powers to act as the owner of the pub, including purchase of cigars, and did not need, therefore, any authority from anybody else. Another explanation is that a manager of the pub usually can buy various things, including cigars, so the third party might not be simply aware of it. And there's another explanation that this is a very special case of constructive authority, that we construe authority from the circumstances of the case. That the owner of the pub leaves the manager in such a position that we can construe authority based on the facts. And this view is currently the view of Peter Watts, who's one of the editors of the key text on agency practitioners text, Boasted and Reynolds. Reynolds was the original author of that text, and he also authored the chapter in English private law, which you had on your reading list. So it's a controversial case and doesn't fit very easily. The best way for you to use this case, I suppose, is to think about in what way it could be explained, but more crucially, I think, is to think in what way, if any, an analogy could be drawn between the facts in front of you in a problem question and that particular case. So the question will always be whether a third party could sue the undisclosed principal even though the agent had no authority. There were some answers in the past on a question which did draw this analogy, and someone said that this doctrine might enable a principal to sue the third party, and this doctrine does not allow that, so it only works in favour of the third party. Now, the remainder of the session focuses on the relationship between the agent and the third party, and the relationship between the agent and the principal. Now, in practice, and the majority of the issues are in relation to authority and the relationship between the principal and the third party, which is what we did until now, and that's why we spend so much time looking at that. But there are a few selected points which I would like to raise. First, the question of, can the agent be liable to the third party? Well, we did say that agent drops out of the picture in a classical agency where they act with actual authority from the principal. There is a contract, for example, a contract concluded directly between the principal and the third party. So the agent should not be liable. But there are some circumstances where the third party can successfully argue that the agent is liable. There are 4, broadly speaking, causes of action, and they are listed on the handout. There are 2 that I want to focus on because they're specific to agency and you will not have come across them before. One is the breach of warranty of authority. So, as Lord Esher tells us in Fairbank and Humphreys, where a person, by asserting that he has authority, induces another, the third party, to enter into a contract, to a transaction, which they would not have entered otherwise, but for this inducement, this representation that they have authority to act. Even though they actually don't have that authority, this representation is untrue, the person who makes this representation, the agent, is liable for what's called breach of warranty of authority. Because they say they have authority to act, they therefore assume liability towards the third party if that third party acts in reliance. So, for example, enters into a contract with the agent and undertakes liabilities to the agent, then the third party may be able to argue that there's been a breach of warranty of authority. The agent is liable, and the agent is liable no matter how innocently this representation is made. There is a case of Penn and Bristol which concerned solicitor acting in conveyancing on behalf of husband and wife. And the husband's forged signature of the wife on the document, and the conveyancing went ahead. It was clear fraud on the part of the husband. The solicitor was oblivious to it. They had no idea that this forgery took place. And nevertheless, the court held that the solicitor was liable for breach of warranty of authority because they represented that they had authority to act on behalf of both the husband and the wife in the sale of the house. This is incidentally why the insurance of conveyancing solicitors is much higher than everybody else's, because they do assume liability for things like that, breach of warranty of authority. Another aspect, before we go on to talk about the rest, so we need to think about the situation where from the perspective of the third party who is able to sue the agent for breach of warranty of liability, and they might be able to argue that the principal is liable too, for example, on the basis of apparent authority. So it might be that the agent has two causes of action available to them. The question is, can they get two remedies, two judgments, and recover twice for the loss they have suffered? What do you think the answer is? No. Now, we know the answer. That cannot happen. The more difficult question is, how do we get there? How do we justify the inability of the agent to sue and recover both against the principal and the agent? So, first of all, let's lay the options. From the perspective of the third party, they're entitled to hold liable only the principal. They can make the choice to sue only the principal. They might only sue the agent, and that's again straightforward. It does not raise the problems. It's when they sue both. Lord Justice Scratton in Debenhams and Perkins says that the third party cannot recover against both, cannot recover the judgment against both. And it might be the case on specific facts that in the contract that the agent has concluded was such that the principal also assumed liability jointly and severely with the agent. And if it was unambiguous, then both the agent and the principal, in accordance with the contract, will be jointly and severely liable. But when the contract is silent, the liability must be alternative. So it must be that the recovery of the judgment is against the agent or the principal. One way to explain how we get there is to think about the doctrine, the so-called doctrine of merger. So this refers to the rule that a judgment against one party jointly liable on a debt with another means that another party is automatically freed from liability. So as soon as the judgment is passed against one party, the other is freed because it's thought that the judgment merges the two causes of action in one. The difficulty with this explanation is the Civil Liability Contribution Act 1978, which tells us that judgment recovered against any person liable in respect of any debt or damage shall not bar action against a person who is jointly liable with him. So that act precludes the operation explanation of the liability based on the doctrine of merger. But it shouldn't suggest that the third party can obtain judgment against both, right? Because we said that that's not right, and Lord Justice Scratton also told us that this cannot happen. So we need to think about other options of explaining this choice. And it seems that the doctrine of election comes up as a possible way of explaining this. Election is a form of a power for the third party to choose whether to sue the third party. For the third party to choose whether they sue the agent or the principal. Election must be clear, of course. Once the final judgment is passed by the court, the judgment will identify who is liable. But up until then, it's up to the third party to choose whether to go after the agent or the principal. Conversely, we could say, well, during the until the judgment is passed, the third party has the power to elect whether they sue the agent or the principal. But once the judgment is obtained, the third party is thought to have elected to sue only one or the other. Of course, this explanation is not it's not ideal, because practically, from the perspective of the third party, we would say practically they would like to sue both the agent and the principal. And if they only recover part of the judgment against part of their claim against one, they should perhaps be able to recover the rest from the principal. So this can be critiqued. The operation of doctrine of election has been doubted in relation to undisclosed agency in New Zealand case, and you can treat that reference as a additional further reading, if you like. But the main point is that the doctrine of election, whilst the main explanation is not perfect, and we're not quite sure how to best conceptualize why the judgment cannot be recovered against agent and the principal. So it's controversial. Okay. The next topic, we need to think about the relationship between the agent and the principal. And here, we start with the way in which this relationship was concluded. Usually a contract. The principal asks the agent to act on their behalf, to undertake an act on their behalf. And the terms of that contract will also determine the range of rights and duties that arise between those two parties. But there will be other duties that we need to look at. So if we start with contract, obviously some agencies are not concluded by contract, so agent agrees to act on behalf of a principal gratuitously as a volunteer, and that will be a binding relationship, but there will be no contract to be the source of rights and duties. So a gratuitous agent is not bound to do anything, at least not contractually, of course. But there might be other sources of their liability, for example, tort, if they undertake an act that triggers tortious liability. And one area that's important for agents is the tortious liability in negligence for their ability, for their duty to exercise reasonable care and skill. A good illustration of this is the Chaudhry and Prabhakar case, where a principal asked a friend to find her second-hand car that was not involved in an accident. And the friend went off and found a car. The friend was told that there was something wrong with the bonnet, but they did not make inquiries. They didn't ask, why? What's wrong with it? What happened to this car? And they bought the car on behalf of the principal. It later turned out that the car was completely worthless. It was unroadworthy. So the principal sued the agent for negligence. And Lord Justice Stuart Smith says in very clear words that it doesn't matter that there was no business connection between those two parties, that this was a social occasion, but it wasn't a social occasion as in completely not to generate legal obligations. There was still a duty on behalf of the agent to act reasonably. And the principal, what's important, relied on the agent's skill and judgment. The friend, the agent, might not have known much about the cars, but the principal probably knew even less. In that case, the agent will be liable for breach of the duty to take reasonable care. The agent also owes a range of fiduciary duties to the principal. These are the nature of these duties. I hope you're well familiar with by now. It does involve a duty not to make an unauthorized profit out of the discharge of the non-fiduciary duties owed to the principal, and also the no conflict rule. So they mustn't put themselves in a position that their position would conflict with that of the principal's interest. The nature of fiduciary duties is not something that we focus on here in detail, but it is important that you are aware that an agent could be liable for breach of fiduciary duty. The more difficult area is the duty to account to the principal, because agents will very frequently buy or sell on behalf of the principal. So they will handle money on behalf of the principal. And it's important to distinguish between the duty to hand over the money received on behalf of the principal and the fiduciary duties. When the agent obtains a sum of money on behalf of the principal, for example, the price from the third party for the goods, then they are under a legal obligation to pay that money to the principal. This is not a fiduciary duty. They don't have to do it because they're loyal, but because there is a legal obligation to, a common law obligation, to pay the money to the principal. It's a legal duty, as Cockburn and Blackburn and Archibald tell us in Morrison Thompson. It's a legal duty to pay over the amount as absolutely belonging to the employer. In other words, it's a personal duty to account. It's not money held in trust just by virtue of the agent holding the money. That ought to be paid to the principal. And in some circumstances, some forms of agencies might involve the agent taking money from the third party, but they need to account for their own expenses and their own disbursements. So they will pass only some of that money to the principal, and some of it the agent will keep. And that duty is captured within another form of duty, which is the duty to account in equity. And the distinction between those duties, the accounting duties, and the fiduciary duties and trustees' duties are very well described by James Penner in his article. He makes that, I think, quite clear, that some relationships will involve the liability to account. And this does not mean that the liability to account is automatically fiduciary, for example. It will just generate, as Lord Justice Millett says in Paragon, a liability to account, a personal obligation, and whether or not it is that sort of obligation, we need to look at whether they are an accounting party. So we need to establish the accounting liability as a self-standing form of liability, separate from duty to hold property on trust, for example, or separate from the duty not to take profits, unauthorized profits or bribes, as in fiduciary duty. And so I would encourage you, just to wrap this up, I would encourage you to take a look at James Penner's article, which is referred to in the reading materials, and to think about the nature not the nature, but rather the distinctions between the duties that the agent might owe to the third party, but also to the principal. That's it in terms of agency. I do not have time, unfortunately, anymore to take questions now. But if you do have any questions, then I'm available after the lecture, or email me. Thanks.
You're available now?
Well, I'm available for 5 or 10 minutes. So,
Yeah.